We are. I mean,
You didn't even miss it.
amazing.
Of course,
I just ignored everybody.
You know, the
We are live,
last.
over live. Hi, everyone.
Oh, goodness. Okay, this is Senate Natural Resources and Energy, and it is a Wednesday, February 4th. And we have a variety of topics to talk about today. So we're going to be jumping around a little bit. We're going to start with a new draft of S224. And just for context, this is a draft that I worked with Legislative Council on in the spirit of trying to address some of the things that I felt like we heard. And we are starting to get to the point where I think, you know, we don't have to do all of the things, or if we have opinions about stuff, I'm gonna start to want to, you know, have that discussion and know what you're thinking about stuff. But as we start to refine, but all that is to say that the draft that we're looking at right now doesn't have to be the draft that we move. So I want to continue to be open to suggestions. It's kind of an interim second draft. So I'll love to invite Legislative Council up.
Oh, sorry.
So Mr. Grady, welcome.
Good morning. I'm just gonna walk through the draft. That's okay.
Oh, yes.
So hopefully you all have a copy of draft 2.1 with the February 2nd date, 4:41 timestamp. Yes.
41.
Okay. So first section is that authority for the municipality to petition ANR for the delegation over the use of waters. And you will see on page 2 that there's still the existing ability of the municipality to petition and to for ANR to award limited delegation or full delegation. That remains part of statute. But what you are continuing to do on page 2, line 13, is the ability of a municipal select board for the commissioners of public water system to petition for delegation and to have delegation. It says shall delegate authority to regulate the use of a public water when public water serves as a source of drinking water or a municipally operated public water system, and the municipality that operates the public water system owns or controls all of the public requirements surrounding the public water, and the municipality accepts the delegation by adopting bylaw or ordinance approved by the secretary. The municipality delegated to regulate the use of a public water shall comply with and be at least as stringent as the state public water supply requirements. Appeals are to the environmental division. Secretary may terminate delegation with cause or without cause upon 6 months notice. One thing that's not here that I think maybe the chair and I discussed, but maybe not the whole committee, and I don't know if the final decision was made, is when the ANR use of waters, that division delegates authority, they don't delegate the authority to regulate fishing or hunting on the water. That remains with the Fish and Wildlife Board. You can delegate that authority. That's authority that you have the authority to give to a municipality if you wanted to. Because that authority is legislative authority and you can direct how that's delegated.
Yes.
So as it's drafted right now, this wouldn't address the
So-
concern that was the sort of concern that brought this bill. Which
But
was
what
the
it could
50
do is
agreements.
this authority could limit access to the water fully. It could prevent boats on the water. It could prevent motors on the water. It could limit the speed of the water. It could limit the number of boats on the water.
Mm.
It has a lot of authority, a lot of potential. But it doesn't give the authority to just prohibit or regulate or limit fishing.
Got it, okay.
That is a point we can discuss further.
So should I move on?
Yeah, sure, unless anybody has thoughts they want to add at this
Just try to
point.
understand it without saying, adding something explicit. People can still fish. And it's clear they can,
Well, what you're gonna create potentially is conflict between the Fish and Wildlife Board, the department, and the municipality with delegated authority. Municipality might say, we regulate, we have the ability to regulate the use, we're saying no fishing, but the board will say. The statute says that we are the one that regulates fishing. What you would need to put in here is notwithstanding the authority for the board or the commissioner. Delegation under this section also allows municipality to regulate fishing on the water.
this fishing in and of itself, that normally imply a boat.
Yeah,
Yes, go ahead.
So, can I get a little more granular about this, because I've been looking at, I've been 1,000 emails about section one wanted, then we want it out of there. Well, you know, first of all, the area that I think we've had testimony is the Berry city water supply. They don't own all the land around that lake.
No, they do. They do,
They own it all,
yes,
even the tributaries. So
they
they
own the land.
can't control the water.
what the problem is that there's a highway. That runs right
Right.
by one side of the lake, and the highway right of way. Extends into the shoreland of the reservoir. And public have the authority to use a highway right of way, including to access. Public waters, and so that is where you have. Where the tension arises, because the public are arguing they have access to the water, the town is arguing, well, we control all the land, we own all the land. And the department is saying, based on the Barry. Berlin Pond decision, that. They don't have the authority to tell the town. That they can prohibit fishing in the water. You have. You can delegate to the town that authority, that is your authority. And that's what the Berlin Pond decision said. The Berlin Pond decision said. If that public health order that the city of Montpelier was relying on had been more explicit about the delegation of authority. Then Montpelier could have limited the use of Berlin Pond. But that public health order was not explicit enough. A grant of authority, and therefore people can now use the surface water for. Thank you.
I think we are going to hear a little bit more about the rule that is related to this later today.
Oh, who's,
The department proposed rule.
okay,
Anyway,
uh,
something related.
moving on, you move out of that municipal delegation and you move to wake boats. And the home lake requirement in section 2. You can skip really to page 5, because that first section, section 2, is just definitions and adding that definition of motor boat and wake boat to the use of waters language. And then on page 5, there would be a new section regarding the use of wake boats on waters of the state. And it provides page 5, lines 3 through 6, person shall operate a wake boat only on the lake authorized by the department for use of wake boats. Page 5, lines 7 through 13, in order to operate a wake boat, the Vermont person who owns or controls wake boat shall on a form provided by the department identify a home lake. There is no longer a decal. The decal is no longer here, but you still have to identify on the home, on a form, that what your home lake is. There is potential in talking with Damon Leonard, our transportation attorney, as part of your registration, to identify that the vessel being registered as a wake boat and potentially to make your home lake declaration upon that form. There's possibility for that if you want to do that.
On the boat registration.
The vessel registration. Yeah.
I mean, that is certainly of interest to me, and to you as well. Okay.
If Damien said, if you're gonna do that, talk to DMV. Never know what DMV is gonna say.
Yeah. I bet I can guess in this case.
So a wake boat's home lake is the only lake on which that wake boat shall be used for the calendar year. Unless the wake boat is decontaminated according to the requirements of subsection C. And this is prior to entering a Vermont lake other than the home lake, prior to re-entering. The person who owns and controls the wake boat shall decontaminate the wake boat at an agency approved decontamination service provider. One of the pieces of testimony that I believe you heard is that existing boat washing stations don't want to be considered decontamination stations. So there's this new sentence that says existing boat washing stations shall not be considered an agency approved decontamination service provider unless approved by the agency to provide decontamination services. Like if they want to and they get approved, then they can.
Great.
On page 6, prior to entering the lake, the law enforcement officer and employee of the agency or a greeter, person staffing an authorized aquatic nutrient species inspection station may request that the person who owns, controls, or is using the wake boat provide proof of decontamination.
Can we pause for a second? I apologize. I think I need to go back to page 5, this new language, which, I mean, I think we might need to add a date to like line 18, like existing boat washing stations as of 2026, because moving on into the future, it becomes, there's a little bit of a cyclical, like it exists and so it's not approved until it is approved, and then I just
With July 1, 2026.
yes.
Do we, another,
Yes.
do we actually need to have the word existing? Because, well, I think what we're saying is a full watering station. It's great, it's a full watering station, but it's not a decontamination station, and once it has.
Right, but I think the chair's point, it should say a boat washing station in existence as of July 1, 2026 shall not be considered the agency to be an agency decontamination unless subsequently approved by the agency.
Wouldn't the same hold true for a station opened up the day after of July 2nd?
Yes, yes. So I see your point.
I
Just
can
to
see
say
your-
boat washing stations are not considered
Decontamination.
unless approved.
Yeah.
I feel that,
But
and then you don't need a date, it's just at any time
Yep.
that they
Yes,
exist.
I like that.
so I have a,
Yes, sure, go for it.
I think it's implied here on page 5. But is this clear that if somebody brings their boat up from Massachusetts or whatever, they can't put it in the waters of the state of Vermont, they have to be contaminated?
That is the vessel requirements apply to all vessels using waters of the state. Regardless of registration. Now,
Existing law?
yeah,
Yes, okay.
There's reciprocity agreements between the states for the ability to use your boat if it's registered in another state and within Vermont. So what the reciprocity agreement provides, you have to comply with the laws of the state that you're operating in.
So are we clear as, just to make sure,
It's okay.
are we clear that somebody actually has to have their lake boat decontaminated? And actually, do we have a time when it has to have been decontaminated? Could it have been decontaminated in May and they put it up in August? After,
That's a there is no time period or durational provision. It has to prove the decontamination prior to entry into the lake.
Would it be, we would want proof of decontamination since the last time it was in a lake.
Yeah, right.
So if it was decontaminated in May, as long as it's not been in the water since May, that's okay.
How are you gonna know?
Yeah, I mean, that is,
Well,
that's stuff, it's like with a lot of things, we just not gonna,
there's no way we can check that.
exactly, unless you use the RF tags.
Okay.
It's just suggested.
So, because I've been thinking about this, because, 2 weeks, 3 weeks, still doesn't tell you anything, because they're still bit about it, I guess that's all. I think this is probably the best we can do.
Yeah.
I talked with a couple of people, industry people, that said that that could be done. I mean, take it to our tag and put it on when they purchase the boat. Well, the problem's gonna be where both things and virgin stuff. Once they have a requirement, to put it in, you can't bring it into the state unless it's our tag.
And what does an RF tag do again?
It basically to tell you where the boat is going, right? If you move it,
Okay,
what was.
GPS tag basically.
yeah, go ahead.
I just want to make sure I understand, so correctly, something you said, are you saying that right now? That a boat coming into the state of Vermont has to be decontaminated?
It doesn't have to be decontaminated, it's subject to the aquatic nuisance inspection requirements. So,
Okay, which could include boat launch,
including, right,
but not necessarily decontaminated.
well, when you take it out of the water, it needs to be inspected.
Yeah.
It needs to be washed, and it needs to drain prior to moving to the next one.
But there's no requirement that you have to decontaminate it by, blasting hot water into the village or the ballast tanks or anything.
It's not that specific.
Okay,
So, well, and I think of, and I think maybe, I think we're probably on the same page about this, but just to make sure that, because I associate the word decontamination specifically with wake boats. As opposed to like all boats.
well, we're only applying it to wake.
Right.
Lots of boats have villages.
Right, and
Sure.
you can see the draining requirement on page 7. It's right now, it's when leaving the water. Prior to transport away from the area for the vessel, if they have to drain the vessel, trailer and other stuff. And then putting the live wells, they don't have to drain their bait boxes. And so there is that draining required.
But that's not considered decontaminated.
That's there because. I think you've heard testimony and I think you probably know that not all aquatic nuisance inspection stations have hot water.
Right, yeah.
Pretty rare.
Yeah, so.
So are you thinking that, well, actually, maybe ask the question first, so to require that a state, or that let's say a wake boat coming into the state would need to decontaminate, that is not required right now.
It's not right now, there's no decontamination for any wake boat right now. There's just draining inspection for aquatic nuisance species that are visible.
But if we were to pass this wake boat rule, and let's say if we added this requirement of, well, maybe it's already here, like requirement to decontaminate. If you're traveling between lakes, that would automatically catch somebody coming in from out of state.
Before you enter the lake, you will have to have decontamination and law enforcement. Agency employee or creator can ask you for proof of decontamination.
Okay.
But you still have a duration issue that Senator Bondar's.
But that would cover all scenarios.
I guess I'm less worried about time, as long as decontamination has happened. Or like if it got came out of some other lake, got decontaminated and then sat, I think that's fine. Is that, which would be covered by this.
So is there a way to make this more explicit so that anybody coming from Massachusetts or wherever is on real notice that their wake boat must carry with it proof of contamination.
But how would you like to provide that notice?
So that's
Yeah,
this
go ahead.
is the enforcement part of it. Who's responsible for it? How, what do they need for access to be able to do this? I mean, but, I think we're telling everybody agrees that we need to do something, we just haven't decided who's gonna do it. And whether they have the assets to do it. So that affects the effectiveness and enforcement.
So the scenario I'm flashing back to is Dynamo, Rocksnot. Everybody remember Rocksnot? And how.
No.
No,
New one, fair enough.
Good job.
So Dynamo is a type of algae that and it's invasive, and when it attaches to rocks, it forms, it's very slimy, very slippery. And it's very difficult to control, and it can affect the health of aquatic species. It can be carried in the felt of your wading boots.
That's why we don't have felt waiting.
Well, we didn't have felt wading boots for a while, they were prohibited. And in order to notify people that they couldn't wear felt, there were signs that were put up, and there was an educational outreach effort that was required from the department. I mean, it's a very similar people going into the water with a piece of equipment that can spread the aquatic invasive species. I mean, I was really aggravated because I just bought a brand new pair of padding myself. But
It's personal.
but I understood, I realized why. But I mean, you're talking about people with a much larger piece of equipment with a much, depending on how big the boat is, the ballast water, what it can carry, it's probably greater than what can be carried in felt waders.
So what I'm hearing, like, because the outreach was signs,
Signage
okay,
and a public outreach.
It seems to me that for this, because the boats are a lot bigger than felt wader boots. You could go into the lake anywhere with boots, like you just walk in.
Yeah.
But with boats, there's just an access point, so it would be easier to have signs there, but. It would require some kind of notice. But to your point also though, if you're driving up from Massachusetts with your boat. And you get there and you're like, oh crap, I didn't know. Then that's a lot bigger problem.
Ignorance is much.
Yeah, so I want.
I
Yeah,
appreciate that sentiment.
I want to plaster this on the internet, so we can
Yeah.
know that this is.
I want it to go viral, no.
This-
Invasive.
Well, we should keep going because I'm appreciating this conversation and the need for outreach. And anyway, I want to pin that reflections.
Clarity.
Yeah,
So we can provide it.
yeah. 'Cause there's more, we should keep going.
Yeah, so on page 6, line 6 through 10, this is new language. Person staffing an authorized aquatic nuisance inspection station is authorized to inform a person who owns or controls that wake boat, whether wake boats are authorized for use on the lake. That information should not be considered law enforcement authority, and that's as much to benefit greeters as it is to benefit the owner or controller of the wake boat. They need to know that the greeters need to know that they don't have law enforcement authority. They can just inform. And then the wake boat operator can do what they want. And the greeter can inform law enforcement if necessary.
You're on page 6, is that right?
I'm on page 6, line 6 through 10.
Yeah, I feel like that's clarifying.
They could also, while we're in that sense, they could also inform them that the boat must have been, the boat must have been decontaminated.
But that's already, page 6, line 1 through 5, they can request proof of decontamination.
Got it, good.
So page 6, 11 through 14. All of the provisions related to aquatic nuisance species inspection apply to wake boats. Wake boat users need to drain their ballast tanks. And what is being added is it's immediately before or immediately after leaving water. I think you heard testimony that when it's easier for them to drain while they are in their home lake. And so that was added on page 6, lines 13.
It just, previously it just said immediately after.
Yes.
And I heard from, one of the things I heard was that it is hard to get a wake boat, or it can be hard to get a wake boat out of the water while the ballast tank is. So like, all right, you have to drain it before or after, but water's heavy.
On page 6, line 15 through 21, the violation or enforcement is going to be through the Judicial Bureau. Judicial Bureau of Minor Civil Offenses. Use of waters violations are already Judicial Bureau offenses. However, whenever you add anything to the Judicial Bureau authority, I recommend you talk to the administrative judge. Just so he's aware, they don't like to be surprised.
Do you know who specifically that is?
Judge Snre.
Zoning, okay, we need zoning, okay. And specifically about section 4.
Right, adding the wake boat violations to Judicial Bureau authority. They already have the other use of waters authority. And so just so they're on notice.
Yep, okay. Thank you, I think you had said that before and it didn't stick, but it's sticking now, so.
Page 7, line 7, section 5. This is the existing aquatic nuisance inspection, drainage, etc. We already looked at it, but it's adding an immediately before and immediately after condition on that. That brings you on page 8 to line 10, section 6. This is the use of fish and wildlife access area by aquatic nuisance inspection stations. This is I'm sure you're probably hearing from people about this.
What's about this?
Yeah, let's press this.
Okay.
Mostly about section 1.
Okay, well, you should know that there's a little bit of there's a weird dynamic with this because the state rule is based on the old federal rule. The federal rule was amended in 2020. And the federal rule no longer has that provision about conflicting priority uses. But your state rule still does. So if someone comes and says that the rule doesn't allow for these uses that conflict, that's not necessarily true. Because the current federal rule says a state agency may allow commercial, recreational, and other secondary uses of a grant-funded parcel of land or water or capital improvement if these secondary uses do not interfere with the authorized purpose of the grant. Well, the authorized purposes of grants include things like wildlife preservation, the management of fish, the management of wildlife habitat, and protection of wildlife habitat, and protection of wildlife. So
And that's included now at the federal level?
that's in the federal level, that's an authorized use. What you probably need to do is look at maybe the Joe's Pond grant and see what their authorized uses were. But you have 3 years to do that, because even if there's a conflict in the authorized uses, the federal rule says the state has 3 years to figure out how to eliminate that conflict or that unauthorized use. So if someone tells you that you're gonna lose money on this, that you're gonna have to give money back for Joe's Pond access area or some other access area, well, you got 3 years to figure that out. And that's basically what I have to say.
That is very interesting. It makes me feel like we need to. If we had more time, I would wanna do a deeper, like, reformation of this. To perhaps match. The federal law.
And that you have the authority to rewrite the Fish and Wildlife Board rules, because when in 1961. When you authorized the Fish and Wildlife Board, you also authorized the Fish and Wildlife rules. In statute, that's why the Fish and Wildlife rules are in statute. If you didn't know that they are there, they are there. And you said at that time. Find it. Basically, you said at that time that the General Assembly can amend the Fish and Wildlife rules however they want. Right, so until such time as amended, revoked, or sued, proceeded by the act of the General Assembly or by the Fish and Game Board. So there's dual authority to amend the fish and wildlife rules. So you can do that at any time.
Yes, oh, let's go to Senator Hardy first and then Senator Bliss.
I am just, what is the new language that was added on, is page 10 is from the last draft?
Yes,
Okay,
It's just some new information.
okay, cause I'm thinking about the testimony we heard about. How these decontamination stations are really large and require tons of water. And may not be appropriate to have just right at boat access station, spots. So I'm a little concerned about that, cause I do think it will cause conflict and it will cause like. There's just not gonna be room for them. And also you need to drain the water, and I'm afraid the water will just drain into the lake.
Exactly.
Wait a second, that's exactly what we don't want.
Right.
So it seems like we might not want these things there, and that we want them like at boats. Boat dealer places that are away from the lake, or marinas that have spaces or something, and. So I guess I'm concerned about this language.
I will say that when the department testified before, they made a statement that was a little bit vague and a little bit veiled. They said that they believe that this language would take away their physical control of the access area. And they said that because there's a provision in the new federal rule that says the state agency has to maintain physical control over the access area, the grant funded access area. And the control must be adequate for the protection, maintenance, and use of the improvement for its authorized purpose during its useful life. Again, what is the authorized purpose of that access area? Is it specific? Is it only for fishing and hunting? Or is it for improvement, wildlife management, etc.? Which most of the grants probably have a statement about that. Because the Sport Fish Recreation Act has this provision, or previously had a provision that would allow for motorboat access for. So I'm just like. They made that statement for a purpose. They made that statement to say that because you can't move the aquatic nuisance inspection station readily, that it's going to take physical control of that access area. And therefore they wouldn't have physical control. I think there's ways to look into that.
Yes.
It said Hardy was something that I've been pondering, like. If that's argument about having a decon station close to a lake. What about our boat washing stations? Like, what rules and guidelines do they have as far as, offset from a water body or?
So most of that is it's dual. It's like the lake associations, they do their best. And they also rely on what the department recommends. Best practices.
Okay. All right.
Something that would be useful is learning more about the decontamination. I'm appreciating your question because, but washing, I'm actually more worried about than the decontamination stations because if, as part of the, as I'm imagining it, as part of the purpose of having the hot water. Like what does that do in terms of reducing the risk from the runoff? But I'm making an assumption there and sort of checking.
I mean, people walk through that, trailers go through that, they go into the lake, I mean, it's all right there.
Yeah.
So I've already talked to some people that consider putting in deep rounds at the station. You need real estate to do it, and it's almost gotta be a public-private partnership. For somebody to start a business to decon, but we don't know how many weight boats are in the state for the impact.
About 100, I think.
It's not, well, they don't actually have the data because we don't register any weight boats, so. And people can come in with them from other states. So.
I feel like if that's all we do, that'll be a win.
Right, so who do you, maybe if somebody. Did that, I know the greeters, the lake associations, they don't want, they wanna keep doing what they're doing, they don't wanna have the state come in and start controlling. So you got more issues here to deal with than just weight limits.
Well, let me think about, I feel like there's a lot here, there's a lot to chew on. And what the right course is, so. Let's keep going for
Okay.
now.
If you wanna skip to the next major subject?
Sure, what are we skipping?
Well, you'd be skipping over that fish and wildlife rule for the use of fish and wildlife access areas. It's all the same question about who gets to use, when it's gonna use.
Sure. And I'll just say for that section, so like page 13, I was, hearing about like people being cited for having like launching kayaks just seems silly to me, and I would love for people to be able to use these points. So that we can have different opinions, and that's all right. But it made sense to me that we should be allowing.
So the one that kayaks were allowed,
Mhm.
as long as they were not commercial.
Mhm.
What wasn't allowed were stand-up paddles. And so stand-up paddle boards have been added and clarified as being authorized, non-motorized. And frankly, you can fish from the stand-up paddles. So.
If you have really good.
Sorry, we go back. Some people can fit.
Here, there. And I on page 15 just curious in sailboards.
Because that was the basis for not allowing stand-up paddle boards, that they were considered sales.
Oh, interesting. Okay.
So if you you don't like it, we could talk about it. That was at least my thinking.
Got it.
On page 16 at the bottom, line 19 and 20, going on to page 17, this is about fishing tournaments. What is added here on page 17 is that if the department receives an application for a fishing tournament on a water of the state that serves as a public drinking water source, and the municipality owns or controls all of the land surrounding the water, the department shall confirm that the legislative body of the municipality approved the use of the water for the tournament prior to issuing the permit. So it's not just the department that has to approve the tournament, it is the municipality that owns or controls that water use as a public water.
Yes.
Well, a couple of questions. How many, the municipality owns or controls all the land surrounding water, is there just one of those? Is it just the area?
No, there are 11.
There are 11. Oh, I think you. did
11
say that.
municipalities and 14 waters.
Okay, interesting, okay, because I was just wondering if we needed that phrase, and maybe it's just if that serves as a municipality's drinking water source. But I don't know,
I'm game for that change.
I don't know how that would change it or not.
So you would bring Lake Champlain as an
Oh, okay, then we could, yeah, okay. Yeah, big like,
And
but, the. does this conflict with other, the like constitutional right to fish kind of thing, or the other sort of authorities of the department in some way?
No, because the constitutional right to hunt and fish is subject to, controls established by the General Assembly.
Okay,
And for example, you have set multiple provisions in statute and then in the delegated authority to Fish and Wildlife Board through rule that limits fishing on certain areas or limits types of fishing, limits methods of fishing, limits what you can use to fish. So there are multiple provisions that restrict the constitutional right to hunt and fish as authorized by the Constitution.
okay, that's helpful to know.
Let's go ahead.
So what do you, I just wanna just ask the committee, what's the general consensus of why, section eight? If we're adding another layer of bureaucracy. For, and. No, so now you have to get approval from Fish and Wildlife, to have a fishing term. And now you gotta get a permit from the municipality too, is it because they wanna be informed when you're doing that? So they can go down and make sure nobody's littering or dumping gasoline in water.
Well, as I heard it from the city manager of Barry, that they're gonna be having overtime police patrols to ensure that their drinking water source is not contaminated because of the fishing tournament. So that to me seems like we have inadvertently set up an avoidable conflict. And so this is, so it's not, they have to get another permit, it's just that as a part of the permit process, there just has to be one more check. So that a municipality like Barry, or like any of these 11 municipalities, don't feel like they need to, have additional enforcement, out there, that seems.
So if the Berry Fishing Game Club decides they're gonna have a fishing tournament, where would they start?
So I think they would want to keep the municipality informed. I think that they'd also then go through the regular fishing application tournament, purpose.
It seems like with this language, they would have to get the Barry City Council to vote to approve it first, and then get a permit from the state.
And it sounds like it's not necessarily, because Barry allows fishing, but they're worried about the volume.
Well, it's a time issue, because I used to set up fishing derbies on Lake St. Catherine,
Nice.
and you have to get the state to finalize the approval. And then you're watching the calendar and watching the weather, because the ice may not be safe. This may just make terms impossible without adding another layer.
Well, I think that, what I would say is that layer is, worth considering when it's a town's drinking water source. So just gotta have an extra pause to be like, is this appropriate, and is the municipality okay with it? Because it's their drinking water source. But open to, that's at least what I would say, but open to the conversation.
And
Yes,
we could, to address your concern, Senator, we could put some, like, that the legislative body must act on the request within a certain amount of time period, so that there's not a delay, like, they can't just sit on it and never take it up, they have to act on it.
They meet every 2 weeks.
yeah, so that seems reasonable.
Within 15 days.
Yeah,
You might want to get the permission. It's involved select boards meet every other week, I'm not sure.
Not all of them, no.
Well, that's even, it's.
Yeah, some of them pretty,
would that help? Brady?
Or at their next regularly scheduled meeting.
I think section
Yeah.
8, well,
But maybe at their next,
Regularly scheduled.
yeah,
I'll put in alternatives for you.
okay.
So there's additional language in section 8, it is related to the cost to the municipality, that is where the tournament is ongoing and the municipality uses that water for public drinking water source. If the commissioner approves that fishing tournament on water of the state that serves as the public drinking water source for the municipality, Commissioner shall require the applicant for the tournament to reimburse the municipality for the costs the municipality incurs, and ensuring that the drinking water source is not contaminated. If that municipality owns or control all the lands.
Just want to recognize the provocative.
I'm just wondering if there will be a dispute about what the costs are, like the town might say, well, we needed to have extra police out because of all the people. But is the police presence a cost that's protecting the drinking water? I think there could be some ambiguity about what it is, and I'm gonna guess that DEC is going to argue that they don't approve fishing tournaments that are gonna impair the waters of the state, but I can let them make that argument, but I think they have already.
And I think the answer there is if it contaminates and it doesn't.
Yeah, get it, but I think that's their argument anyway. Obviously, there's a difference of opinion, but I think I understand why you would include this, but I am just concerned about the definition of what those costs might be and being unclear.
Yeah. Go ahead.
So just want to remind everybody why fishing game clubs have derbies. It's normally to raise money to send kids to conservation camp, unlike the Lake Champlain International, where, you know, it affects commerce and brings funds into the state. These don't. These are all usually they're conservationists who like to hunt, fish, and really take care of, you know, they're concerned about aquatics, invasives, and, you know, dumping gas in them, and I've seen them actually go over and say, hey, you know, I drink that water, and I'm like, don't be gas in the
It's my share of fishing group. You'll be doing some soon.
I hope so. I hope so.
So. And you're right, and I agree. We had talked at one point about the notion of the application. Adding to the application, something about description about how access will be achieved. Did we do that?
Did we take that out?
That's just taken out.
If you, because if you're getting. Trying to target. The problem.
Well, actually, it's still in there.
Okay.
Still, I'm sorry, page 18, line 17. Applications. The form shall require the applicant to identify and
Oh,
access
yeah.
point of waters for participants in employment.
I think there's multiple. Open to that conversation.
Makes sense, which is know how the access can be achieved, will they approve?
Yeah.
So,
Yeah.
So,
Okay, thank you.
I think I'll be back, right?
I think you'll be back. Really appreciating the conversation that we just had, and, sure. Well, anyway, would love to, come back with another draft of it, so.
Are you hearing from Brian Redmond today on 2/12? No, tomorrow.
No. We were gonna have him back tomorrow, but because I had a related question, but I emailed him my question and got that, I think,
Okay.
resolved, so I'm happy to post that exchange if that's useful to anyone, but.
Okay, so I don't have direction on what to do with 2/12.
I think there,
There were
okay.
two
well, I
issues,
need-
whether or not to allow individual permits. And whether or not to have a tiered permit system based on the complexity of the connection.
So I took some notes based on our conversation yesterday, which I can email you, which I realize is. I mean, we're hoping for a new draft of 2/12 Friday,
Okay,
so, and more to come on 2/13, but,
right,
yeah.
right.
Yeah, yes,
Is there one document where the fishing game rules are like? Well, 1962.
Well, remarkably, a lot of the 1961 rules still exist as they were enacted in 1961. But you can get them right there, Title 10 Act. They're all right there.
Okay.
thank you.
Thank you so much.
Yeah. We can. I don't know how long whatever we would make that. Yeah.
Okay. All right, we are gonna switch topics, and we're coming back to, the committee bill that we voted out, brought back to committee. S 325, and which is largely based on the Let's Build Homes, proposal about, some model bylaws, and we have, Mr. Weinberger with us, welcome.
Thank you.
Yeah,
Just a copy of
yes,
this number.
I think we have this as a draft,
Yeah.
but this was.
So-
Yeah.
My place is already. Okay. Maybe it's
Oh, well.
You.
You know, to get this right, to be more,
More
lots of
budget.
good stuff, including the questions.
Super, well, and thank you for being here.
Yeah, it's, I really appreciate you having us in and already taking action to, take a step towards exploring the possibility of what we've been calling root zones. I think in the bill that, acronym may have become rude, a little concerned about that. But hoping that's one of a number of things we might be able to sort of talk about in these early stages.
Yeah.
I do have a slide deck, let me pull that up. Great, so, again, thank you for having me in, Mauro Weinberger. Had the privilege of serving with, the chair when we were both, part of the Vermont Mayor's Coalition, the hat I'm testifying under today is as the executive chair of Let's Build Homes, which is, still quite new organization. We launched about a year ago. This is my first time I think anyone from Let's Build Homes has testified in front of this committee. So just to say very quickly a little bit more about what this coalition is. We over the last year have grown into a coalition of almost 270 organizations, with over 900 Vermonters, individuals and organizations from every county in the state. We're a little over represented in the north and underrepresented in the south, but truly, even the Northeast Kingdom is overrepresented. There's a strong interest in the issue of housing statewide. The more so than just the number of organizations that have been part of the coalition, I think is notable is and somewhat different than past housing coalitions. It's just the breadth of it. You certainly have what you would think of as the housing usual suspects, whether those are nonprofit or for-profit developers, business community. There are a lot of hospitals that are part of this. There are a lot of utilities, there are secondary education institutions. And I think a sign of just how significant our housing shortage has gotten and the impact it's having on workforce issues. We have AARP as part of this, down to groups like, in Chittenden County, there's something called BPOP, which is basically 20 and 30 something folks who call themselves Vermonters for people oriented places and they care about housing. So this is our mission. I think what is relevant to today's discussion, just to highlight, is we see it as our job to certainly create more housing opportunity, abundant housing as we call it, for households of all income levels. We are very committed, and other communications we have sent you and your colleagues support the continued public investment in housing subsidy. Updating my operating system and there's some weird glitches.
Oh, no.
Here this morning. Sorry if there's some flashing. It's doing some weird things here. We think we need to broaden the lens to truly address Vermont's housing issues. We need not just to build more permanently affordable housing, we need to build more housing of all shapes and sizes for all of our neighbors. We think there's a way to do that in harmony with our working lands, and I think this bill would be add to the tools that you have already created that ensure that. And just final slide on the sort of introductory. We're very focused on the needs assessment that was published in late 2024 by the Vermont Housing Finance Agency. And these are two graphs that me sort of summarize our challenge. The graph on the right being what we have been producing in terms of housing production, going back a little over 10 years. 2025 numbers are not fully in yet, but my understanding is that it will again be a year like the last year, which has, I think, reasons to be hopeful that we are the work that you have done and work the municipalities is doing is increasing housing supply. It will be another kind of relatively big year. It will still be a year well below what the state's sort of official housing targets are, which says to us, you know, we need to keep working, we need to keep moving.
Just a clarifying question,
Yeah.
Darryl. In figure 3, when it says occupied, is the definition of occupied like a 12-month resident? Or,
Yes, that's my understanding of that graph is an attempt to distinguish between permanent housing production versus secondary home production.
okay, thank you.
And you can see that it's dropped dramatically since where we were you know, a few decades back, which to me is a reason to be concerned about where we're at, but also hopeful that we don't have to go back that far in our history to see a time when we, you know, we were producing homes at a level that was keeping up with our needs. Here's the rest of my presentation gets into this concept of residential opportunity, overlay towns, root zones. You know, still a little new to the ways of capital here, but I have learned that you need to get into good acronyms, so sorry, shot at that. No, not too much pride of authorship if people have a better idea. I'm gonna spend a little time talking about why we think this is potentially an important intervention for the legislature to take. Give a high level presentation on how implementation could work. Kind of lay out what would be in a state model code in this sort of model code that we're calling root zones. You know, I'm mindful that we've just been scheduled for a half hour today. I know we're sort of behind schedule, so I try to keep it at a high level with the thought that if there is interest in pursuing this further, we're actually working with a couple experts we'd love to bring back and get into more of the details. And I will just say out of the box, I grateful and was, you know, we're very excited that you already taken the step to write up the possibility for a task force on this. And if that's where we end at the end of this session is on a task force, that would be very exciting, and we would make we'd use that opportunity to its fullest. We also come to this work with a sense of urgency, with the sense that, you know, we have Vermonters suffering right now in our homeless shelters at risk of eviction. We think there's urgency to trying to change that trajectory that I just had up a moment ago. And the actual legislative intervention we think here would be fairly straightforward. I'd like to think, at least to start the conversation, thinking it might be possible to do more than create a task force this year, and then we could actually, you know, move to some level of action. Why do this? This primarily comes out of a broader conversation that is going on. The legislature has encouraged action on and discussion on with your provision within Act 181 to look at the permit appeal system. And as you know, the Land Use Review Board produced a report on that appeal system. And just to go ahead to this, you know, that report has many important worthy discussions in it. It has this one note that I'm focused on here, which is that the concept of by right permits under certain conditions was advocated for by many of our housing experts. It was supported, typo there, sorry, by BNRC as a compelling idea that needs more time and discussion, as it could speed up the production of housing in an effective way. The report doesn't go further into that. What we are doing here is, I think, should be seen as one of several efforts underway right now to look at that kind of exciting opportunity of some consensus and say, what more can we do there? I do think the governor's 802 homes program should be understood as one of these attempts to create by right housing. I know you're hearing from BNRC after me today, and we've had some good discussions about potentially other state mandates that could be kind of direct ways for the state to get into this role of encouraging by right development. And I personally, Westboro Homes is supportive of all that. What we've tried to do here with root zones is an attempt to I guess while we're supportive of all those efforts, we look back at the history of, for example, ADU reform in this state. And the way I see that history, like the state has been encouraging accessory dwelling units to be built going all the way back to the nineties. There was like a bill back in the nineties that said ADUs should now be legal. And Burlington took similar actions at the municipal level, trying to mandate the legalization. And what we found is that those mandates had a limited impact until you really got into the DNA of how we regulate housing at the local level. You got into the zoning details like lot coverage ratios and parking requirements and setback requirements and you know, we had a comprehensive reform in 2018 in Burlington that that did that, and finally after that we have seen some uptick. I have some. I'm both hopeful that there are things that can be mandated about by right zoning that are simple, but also some concern that until you really kind of get into the DNA of zoning, you're not really going to crack this nut, and that's what root zones attempts to do. There are some additional purposes that I'll touch on, but really that's the main purpose of this, is to address permit appeals, which I will say my priors here. I think this permit appeal system issue is a very serious issue. The report from the LURB acknowledges that. They document, you know, dozens of appeals around the state every year. I think what we can see in some ways is just the tip of the iceberg, and I say that. I'd like to just share a kind of personal story that maybe explains a little bit why I'm here in front of you. I was a builder before I was the mayor of Burlington, and we attempted to build one much needed 25-unit apartment building on North Avenue, one of the main arterials in Burlington. It was held up by appeal by essentially, you know, one neighbor for 5 years. Took us from 2003 until 2008, so from a housing boom until a housing recession. We stuck with it for another 5 years, eventually got it built, and 25 households live in that building today, until including 5 permanently affordable homes. It's one of the few truly sort of 80-20 mixed income developments in, you know, most of our affordable housing doesn't get built that way. It was one of the few such projects Burlington had. Proud we got it done. We never attempted another one. It was a harrowing experience. It nearly bankrupted us as a company. We were years into it and millions of dollars into acquiring this and really not knowing we'd be able to build anything. I truly don't think we will have a functional housing system until we crack this nut of addressing permitting. And I have a further slide I want to show you here that comes also from my experience of trying to address this at the municipal level with some success. What I learned about that tough experience was that the appeals, the debates happen, the lawyers argue over the subjective elements of the zoning ordinance. The appeal of our project was about the character, whether or not we met the character of their neighborhood. You know, we brought in John Anderson, a great architect, to make the argument that we did. But you know, so you and I could argue all day long about whether something meets the character of the neighborhood, or more to the point, our lawyers could argue for years. I know you've addressed that with Act 181, you've taken out that particular test, but many other subjective tests remain. Burlington had subjective parking waivers. We had undue adverse impact tests about traffic circulation and other other kind of use it. So a lot was put in the language of undue adverse impact and deferred to the DRB, the Development Review Board, to make those decisions. We systematically attempted to remove all of those subjective tests when we did a form-based code for the downtown code, and it took years of work. It's quite expensive for us to do it, and that's a reason for this effort too. But we got it done. It was adopted for the beginning of 2018. We went from before 2018, in my time as mayor, there was basically an appeal every year, close to every year. You know, we're talking small numbers overall, but there were numerous appeals, and even to the point of like some of this is sort of below the tip, you know, below the water level, and you can't really see it. not on the list, of formal appeals or other projects where an appeal was threatened and a project, and that kind of hung over everything. And we spent countless hours in the mayor's office mediating resolutions of appeals or potential appeals. And since 2018, and the form-based code went in, we didn't get it all right. I'd say it is a very fastidious code. It micromanages in some ways. It adds expense. Other experts, witnesses you bring forward, will say negative things about and I feel some negative things about the form-based code, but at a fundamental level, I think it did work, and at least in the sense there has not been a single zoning permit appeal, development permit appeal since 2018. I put an asterisk on that because there have been some like demolition appeals. There was a kind of carryover major project, the City Place project. You guys have seen that. There was an appeal of that predated the form-based code and then kind of continued into it. But so, people could quibble, but basically there has been, I think, a dramatic change. This has basically solved the permit appeal issue, and it's been significant to the city meeting its housing goals in recent years, which is what that lower chart tries to show there, which is why I think this could be a significant strategy for the state. Here's at a high level how root zones would be implemented. If you guys like this idea, the vision is that the state would create a model zoning code. Just to pause on that concept for a moment. I don't have more in the presentation. I could produce more to back this up if you're interested. There's a lot of precedent for this concept of model codes. Zoning became a widespread innovation because Herbert Hoover, when he was the Commerce Secretary, produced like the first national model code, and it caught on like wildfire. And within a few years from that federal action, 70% of the population in the country was living under zoning. There have been many other efforts to come forward with model codes with varying degrees of success, and I think it makes a lot of sense in that zoning is really important. It's very technical. It is a lot of detail in there. It is hard to get right. It is certainly hard for every municipality working on its own to get right. And so that's sort of the appeal of a model code, is that it gives something. You're still, as you see in the next thing, this is I'm envisioning the towns adopting this. This is not a state mandate, but the state would be doing important work to craft this model code. And that is the reaction I've been getting from the handful of municipalities we've talked about this with so far. And I will acknowledge we have more work to do there, but every municipality I've raised this with has expressed some level of openness and thought this could be a helpful tool for them. So State creates this model code, towns adopt it. There is some level of state review that town action, and I do envision there being some customization, and there could be specific things that city of Montpelier might want to do. There would be some review from a state agency, and I think that is probably an area for some debate, who's the right agency to review this, but there would be a state agency review to ensure that the state goals are being met by this model code. And then the kind of magic of this, as I see it, is the actual process of once a root zone is in place, this overlay district. That's what this is, an overlay zoning district that sits on top of the existing zoning and sort of trumps the existing zoning once this is in place. Right now, almost universally, when you come forward for a DRB, a zoning permit in Vermont, it's certainly in one of these towns, the great majority of towns that have these sort of subjective discretionary review processes, you're starting a months-long process, maybe years long, if there is debate about those subjective issues and there is appeal. And instead of that, the review of an application becomes much more straightforward. A zoning administrator is simply going down sort of checkboxes and confirming that the clear and objective rules in this model code are being followed. And if they are, if they're not, you don't get a permit. They are, the issuance of the zoning permit becomes an issuance of a certificate of zoning completion. It is no longer a new governmental subjective decision that triggers appeals rights. It is a certification process and can speed up the process of getting a permit, add certainty to that process, and dramatically reduce the amount of administrative effort as well on the part of these companies.
Thank you, I have a question, so. If a town adopts the model zoning bylaws. Then does that imply that they give up the ability to tweak a plan? You know, so somebody comes in and wants to build an apartment building. And the original plan doesn't, I don't do this stuff, so I'm just gonna make something.
Yeah, no, it's a great question. No, you're right on one of the.
The original plan, the parking lot is too big and there aren't enough trees. Those are
Right.
two of my personal pet peeves. So does the town still have the ability to go back to the developer and say, you need to plant more trees and shrink the parking lot? Or is that in the ordinance itself? Like, so where does that come in, that kind of back and forth come in?
So, great question, and there's several layers of answers to that. First of all, there would be an attempt, and I've got some slides in a moment to show you. This would be, I'm envisioning this as ambitious about what is in the model code. It would cover what we typically think of as sort of the dimensional regulations of zoning. It would be an attempt, if you get this right, it would also. And I said it there at the top, is like, we want to ensure that what gets built is better, it's improvement. And part of that is regulating that public space. You know, we actually have in the zoning in Burlington, in the zoning, rules about what we call kind of great street standards that define the width of the street and ensure that it's walkable and bikeable and that it has good street tree coverage and that there are places for outdoor art. All that's actually in the zoning ordinance, and if we get this right, it would be in this as well. So it would be an attempt to address the most important issues while also being a principle would be to be lean, to not be adding undue expense to the cost of housing. We know the cost of construction is a very real one. So that would be another principle. In particular, and I see this in the work that you have done in 181. If I'm, you know, I was mayoring at the time, was not as, you know, super involved in that process, but I see in the way that you are granting municipalities tier 1 status, an attempt to define what is important to the state, what makes for good development. And I think it's a good list of things. This would kind of go beyond the list and put into design terms, you know, how we ensure that new stuff that gets built is consistent with the historic fabric of Vermont that we love, the walkable, kind of largely rectilinear, mixed use neighborhoods. You could actually have all of that built in.
Okay, so if somebody puts forth a design, the town sees it and it's like, oh, you don't have enough trees, that's in the actual model bylaw, says you need so many trees per whatever. There's still that conversation between the town and the developer. It's just once the town is like, you've met all the requirements in this model bylaw, there can't be an appeal, because the appeal is front loaded.
So I think that's close to what we're gonna get to, but let me take it there. I will say an issue with form-based codes that I've heard from people who the type of code we're talking about here from builders and lawyers who have worked with them. There's often a lot of frustration about them for a variety of reasons. Some of our reasons, like I mentioned, like in Burlington, we kind of put too much in it and it became a hard and expensive code to work with. Another issue is it's very hard to envision it's impossible to envision every scenario, and almost invariably there will be some projects where there will be some element that's not fully contemplated in the kind of model zoning and that requires some level of discretionary decision by the local DRB. And it will be important that for issues that aren't fully worked out and that there be some ability to do that. And that, of course, then that would trigger appeal rights at that point, if you are making some kind of discretionary standard. Again, we can get deeper into it with a lawyer in the future. We are envisioning there being some sort of deferential standard to that decision that keeps permits appeals limited, but yes, like there'll be an attempt to get the issues right up front, and then to
Yeah.
agree there need to be discretionary decisions by the town, conversation discretionary decisions, there would still be a mechanism for doing that.
Okay. Okay, I think I understand. All right, thank you.
Um,
We had the same
great.
such question.
Just say a little bit more about well, I just want to say a little bit more about where this effort stands. We actually, Let's Build Homes has secured some funding to explore this concept, and we are doing that sort of in parallel with this legislative effort, not knowing what would happen here. And because this model code could be helpful to municipalities, even if the legislature does nothing. I think there's a lot to be gained by legislative action, and that's why we're here. We have engaged, as you can see in the blimp there, this firm, Util, which is a planning firm. They're actually based in Boston, but they've done a lot of work in Vermont. They did work in Burlington on several zoning issues. They also are working for the state right now on the governor's 802, they should call it just the governor's, the ACCD's 802 homes proposal. And what they are doing with 802 homes, and which would also be kind of scaled up here, is they're looking very carefully at Vermont's existing residential typologies, trying to sort of understand what is, there's the sense about like a Vermont vernacular, what is the existing fabric made of, and you can see this real variety in it. With the 802 homes program, they have started turning this into these prototypes that what they are envisioning, as you probably are aware, is some kind of state mandate pre-approval of these prototypes. This zoning would dovetail with this effort in that it would, like I mentioned with ADUs, would start to grapple with these other the mandate that is being envisioned right now from the state is limited. It says you still have to meet these other requirements. This zoning would address those other requirements, try to make sure that as towns adopt the model code, it allows these typologies to be easily built, and it would go beyond these, would deal with sort of denser, bigger downtown and arterial buildings as well.
Just to be clear, there's actually no mandate.
Not yet, yeah.
From the state on this is purely designs and interested in local communities, and then they decide if they want to pre-approve the designs of these buildings. That's what it is. There's not a state mandate. So
Thank you for that clarification. I totally agree. That's the current status quo. I'm under the understanding is that there's a proposal from the governor this year to introduce some level of limited mandate. But if that hasn't gotten this committee,
We haven't had it.
yeah. This, it would, this code would have, like I was saying, footprint, height, roof form type regulations. We'll talk about, maybe multiple footprints on properties, getting issues like that. We would talk about, placement of parking lots, how, in many kind of downtown or sort of village forms, you want to try to put the buildings in front of the parking lot. It would have analysis showing how existing neighborhoods, once this model code was adopted, could be densified along the lines that you called for with the Home Act, and show how, kind of really work out the details about how additional structures can be added to existing land. This sort of shows, and as an example that Util has developed for Newton, Massachusetts, but when a municipality is actually implementing a root zone, now there would actually be likely multiple subzones of that, neighborhood type zoning and then different level of density allowed along in major streets and maybe even, you know, another one or two for the downtown. This model code would get into all those issues. To Senator, your point, I think this should attempt to grapple with other issues that the state finds important. And I just wanted to, you know, for what it's worth, this book has been actually quite, shows the wonkiness and I like to say that I find this book moving. It is a book about zoning called Key to the City by Sarah Bronin. She's actually the wife of the former Hartford, Connecticut mayor. She kind of rekindled my belief in zoning and why it's so important. And just to read one paragraph from it, she says, you know, to be sure, zoning is not the only tool that matters. History, time, wealth, geography, and countless other factors will shape how communities evolve and develop. But while good zoning is not sufficient, it is necessary. Most important, it's something we control, and that makes it the key to building the cities and towns we long for. And I think we should attempt to do that with this model code. One last point, and I think I'm basically done, is this isn't a revolutionary idea in the sense that there are, like, well, Burlington's not the only place in the state that has tried to move in this direction away from traditional zoning towards these clear and objective form-based standards. I could come back with a comprehensive analysis of the towns that have done it. I think there's 7 or 8, I need to check a few things, 7 or 8 that have done it. I believe they have seen similar positive impacts in terms of predictability and an increase in investment in the zones that have done this. It has not been easy for the municipalities to do this on a city by city basis. A figure, Charlie Baker, the head of the Chittenden County Regional Planning Commission, says that when they try to help municipalities do this on a kind of one-off basis, they easily spend like $150,000 on municipality doing this. An additional very, I think, concrete benefit if we got this right would very much simplify that existing ongoing effort to create these form-based codes. It would be much easier once this work is done for a municipality to adopt it. Our estimates, you know, these are conceptual at this point, but instead of like $150,000 of additional planning work, we're talking like $25,000 of planning work that might be necessary if we got this original work right. And you know, and I do think that is something that if this, when we talk about why state involvement, I think the state could accelerate the adoption of these zones if they provided some level of municipal support for this follow-up planning work that would be necessary. I think it'd be an interesting discussion to have. Well, a downstream discussion and one it'd be flashed by right up front. I'll go all the way back to the beginning of my presentation. The additional purposes of root zones that, you know, first and foremost, it's the appeals purpose we talked about. We talked about improving the quality of what gets built in these zones. The last two, I think, are worth thinking about as well. If these were broadly adopted, we would be moving towards something of a, right now, Building Vermont is looking at, you know, dozens, if not hundreds of different regulatory environments, depending on where they're trying to build. And that is complication that slows things down, that drives up expense. The state of California, going back to ADUs, I just want to show one slide from another report that I found very striking. It's I screwed up. My apologies. Wait a second. No. I'll send you the slide separately. It shows what has happened in California with ADUs since I'm gonna stop sharing, so I think I've screwed this up. It shows what has happened in California after numerous reform rounds and really creating a state regulatory environment for ADUs. They have seen just an enormous increase in the adoption of ADUs out there. Gone from almost none being built in 2016 to the point where like 25,000 a year are being built in that in that state. It's like a third of all homes in some counties are now these ADUs. So that is a further benefit. If we added, if through this over time, we had some common way in which from municipality to municipality, housing was regulated, I think we could get some of those market efficiencies, construction efficiencies, so we bring down costs and speed up production. And then finally, the final benefit that I thought might be of particular interest to this committee over time is, you know, I know the numbers are still early on this. 181 implementation, I've come to understand, and you know, I know Senator Baumgart's, you were a particular champion of this, and I've come to understand that Act 181 represents a real breakthrough in that we are on our path now towards having these tier 1 areas around the state where really, I think for the first time since Act 250 was passed, we have some really meaningful and legal level of consensus that we want housing to be built in these areas. I'm impressed by the maps, generally speaking, that I've looked at closely in various counties. I think they have a lot of rationality to them, and I think that, you know, they reflect a lot of good thinking and work being done at the regional level and the local level. I also think we are likely to end up in a situation where, the best I can tell from BAFTA, we're now like 2% of the state land area will be in a tier 1 area. I think that's not gonna be enough ultimately to meet our goals. And I think a further value of root zones, if we got this right, might be that this could become a way that the state felt confident in, that maybe environmentalists felt confident in, that could allow for more land area to be brought into tier 1 regulation, the benefits of tier 1 to be opened up to more rural communities and you know, the large areas that we're gonna need to evolve and adopt as we, you know, stop building in floodplains and need to be building in new areas. So that's a final thought as to why this could be a significant effort.
Super. Well, thank you so much. Any questions at this point? Okay, super. Well, more to come on this topic certainly. Thank you. And with that, we're gonna take a quick break. We've been doing it since 9, so let's be.
Thank you. I'm a little scared, there's no questions what that means. If there is any interest in getting this further, we do have good experts lined up that could get into the details and I think really accelerate the conversation about what this could be if there's interest. So
Super. Thank you so much.
Listen, had to create a record.
Listen with curiosity.
So do I. Okay, good morning again, so Natural Resources and Energy coming back from a break. And again, we are in a mode where we are jumping topics today, so thank you for bearing with this, the new switch. We're joined by Mr. Groveman, and I think, are you, for this part, is it just you?
I'm gonna go first and then I'll
Okay,
go over
okay.
to
Um,
Gallagher.
Great, to chat with us about details of appeals, or specific aspects, so.
Yeah, but it's
Yes.
very related to the last topic. So for the record, my name is John Broman. I'm the VRC Policy and Water Program Director. And so I'm gonna talk about appeals generally. You heard a little bit from the mayor about appeals generally and the importance of improving the process. And so I'm gonna try to kind of create a further foundation to some of the appeal issues that have been discussed for a long time. Try to create some context and maybe make some recommendations about kind of moving forward on some of the issues. And then Katie Gallagher, my colleague, who's the director of VRC Sustainable Communities Program, she's going to directly talk about the root zone proposal that you just heard about and S325 and more broadly, the idea that the mayor was talking about in terms of addressing appeals in these growth areas. So before I get into the substance of appeals, generally, just a little bit about my background on this particular issue, because I think it's important. It'll help, as you hear me talk, understand kind of where I'm coming from and how I form some of like my opinions, and some of what I want to do is kind of lay out actual, not opinion, but kind of how things used to work and how they work now. But I'm an attorney. I've been an attorney for Vermont Natural Resources Council. I was in the mid-90s, an attorney for Agency of Natural Resources, and I represented the agency before all the district commissions. I've appeared before every single district commission. I would represent the Agency of Natural Resources, and actually the other state agencies, VTrans and Stark Preservation, and before the former environmental board. And I'll talk about kind of the appeals process changes we've seen, and the Water Resources Board. And then at VRC, and then I was the general counsel for the Agency of Natural Resources in the 2010s-ish. And I represented the agency for the environmental division of the Vermont Superior Court. I represented VRC before the environmental division of the Vermont Superior Court. I represented both VRC and ANR before the Public Utilities Commission. So all this to say, I've seen these issues from a lot of different angles. So I'll just try to bring my perspective from actual experience. And then importantly, I did have the privilege, I was chair of the former Natural Resources Board that administered the Act 50 program. So I got to see the district commission process and the appeals process, from that seat as an administrator of that program. And now, of course, we have the Vermont Land Use Review Board, or LURB, that has replaced the Natural Resources Board. And I was a member of the LURB appeals stakeholder group. So I, attended all the meetings this summer and fall, and participated in the discussion that led to the report. So that's the context. So I just some little brief history. I think I'm going to submit, after I testify, I just couldn't get it done before I came here today. I'll submit this testimony, but I not testified on these issues for a long time in the legislature, at least going back 5 or 6 years, maybe longer. In 2024, I testified about this issue that you heard when the LURB presented its appeals report, and it's in the report. Should we have a professional board that hears environmental permit appeals, or should we stay with the court? I have testimony that again I'll submit because I think it's still relevant. Kind of presents the arguments for the board and the court and some of the issues. And where I come out is that I think moving appeals to a professional board would improve the appeals process, as the mayor indicated that, there's both the root zone idea, but just general improvements to the appeals process. You'll see when I submit that testimony, We actually did an analysis of BRC that we looked at the last 5 years of the environmental board. And then we took 2-year, 5-year periods for the environmental board, starting your Act 250 appeals, and analyzed the timelines that it took. And the environmental board was much quicker. In one timeline, it was, I think, 265 days it took for the environmental board on average to process an appeal. The court, for one time period, was like 460 days, another was like 520 days. And, there's lots of outliers in terms of things, like in terms of the numbers, but it was clear that the old process was faster. And that wasn't surprising in that the environmental board, when it heard Act 250 appeal, that's what it focused on. It heard Act 250 appeal. The court's docket is very, very, very large, and it's got a lot on its plate. They hear Act 250 appeals, they hear zoning appeals, they hear agency of natural resources permit appeal, they hear enforcement appeals related to every single one of those programs. They have 2 judges and 2 law clerks. That's the staffing that they have to do all that work. The environmental board had at least 5 lawyers, and I don't know how many lawyers that the land use review board has right now, but they have at least 3 lawyers. And they have the professional board members at the land use review board. So I think that's part of the reason. I think, as when I talk about the LURB's appeals report and some of its findings, there's just more flexibility in an administrative appeals process where you're in court. It's the rules of civil procedure, it's the rules of evidence, it's very strict, there's not much wiggle room. You have lawyers that are very comfortable in court, and they know how to use all of the procedural rules and the discovery rules, which is when an appeal is filed under the court rules, you get to depose every witness, ask questions of every witness, request documents, there's a long production of document period. That didn't exist in the administrative appeals process that the environmental board ran, and there's all kind of models where there's gonna be some everything from the full discovery and procedure and formality of the court to little to midland, process. So it's a continuum. And I think with court, we don't have that continuum. We kind of swung all the way from very informal and flexible to the court formality. And so, the lawyers are fine with it. I'm fine with it. I like going to court. It's really interesting experience. I've always represented the government or nonprofits, so I don't get paid by the hours. So I don't actually totally enjoy getting buried in discovery. But that's the process. That's the core process. So I think those are some of the reasons. Another strength that you'll see when you look at my testimony that I think the old environmental board brought to appeals was that Act 250 it's obviously complicated, but the way the statute's written, it's not like black and white criteria. It's not like you get a stormwater permit and here's the engineering standards. You build your stormwater system this way. Here's the engineering standards. You build your septic system this way. It's no undue adverse effects on aesthetics. That's what the statute says. There's nothing else there. Do not destroy or significantly imperil necessary wildlife habitat, undefined. So the old environmental board spent decades defining, well, what is destroyed? What is imperiled? What qualifies as wildlife habitat? What qualifies as mitigation? And the board was very good because the people appointed to the board, and it wasn't a professional board, so I think the LURB is much better situated because they are full-time paid and they have to have certain qualifications to be on the LURB. But even without that, the pointing to the environmental board, all the governors have made the appointments, Republicans and Democrats try to choose people who have land use background, environmental background, development background. And so they were able to say, well, what does it mean? Well, what's the test for aesthetics? Like, how do we create some objectivity, around that, or how do we define some of these terms? So,
Go ahead, a question here.
So a question to that, because I'm still learning all the things. So if they spend decades defining things like what is a habitat corridor or what is a damage, does that mean that all of that is defined now in case law?
yes.
That is
that the court or a board could refer to that case law to say this is how that something is defined, so it's not defined in, they didn't issue rules, it's really.
They could have, and I think the LERB will be much better situated because it has more capacity, and that was one of the advantages of creating the LERB is that, you know, so the environmental board was a 9-member, which is also, you know, really interesting that they chose, that's a lot of people.
Yeah.
Try arguing, like I said, you know, like in front of 9 people, I'm trying to, and like I said, all volunteers except for the chair. They had some legal staff, they had, you know, some other administrative staff. But I think they have more capacity with the 5-member professional board to actually turn some of that precedent into rules, which would be a really positive thing. Because we're relying on the precedent that you're talking about. And then also, you know, things change, it's not static, a lot of that precedent was created in the 1980s. So like, what the science changes, like what the terms,
Yeah,
you know.
so if it's in case law and they wanna redefine now something that was determined and defined in 1992 or something.
Right,
And they were like, well, there's new information or new science.
right.
To do it through case law, you have, I mean, that's a long process. to
It is,
sort of-
it is, but you could do it, I mean, I do think that, so the court is just, and I wanna be really clear, and Brooke Dingledine said this, you know, when she testified, you know. Judges work extremely hard, they're extremely capable, nobody is questioning their abilities and their work ethic, but. It's really the system, the court system, they're not an administrative entity,
Mhm.
so like, courts exist to resolve disputes. That's what we have courts for, and they're very good at that. So it's more about. How do we resolve this dispute? Do your discovery, you know, try to work it out. And then we'll look at the evidence, and it's mostly like sort of a battle of the experts. It's like, we have a wildlife biologist, and then the other side has one. And then like, which expert am I more persuaded by? They're less inclined, and it's not really the traditional role of the court to say, you know what, this test for like destroy an imperil wildlife habitat needs to be changed, the science has changed. Because they don't really function that way, that's not something that, whereas the old environmental board, and I think the new land use review board. They could do it on appeal, say, you know what, we've seen the evidence. And a lot of it's gonna come from the agency of natural resources, like a lot of that early precedent, really important, the wildlife biologists there. The agency of natural resources, a hard aesthetic experts, like that was a real tough nut to crack, right? Like, how do we measure aesthetics, and hired someone to basically create what we had called the Gucci test now, which everybody accepts. And it's like, wow, that was a great thing that we have, but it didn't exist it's not in the statute.
Sorry, so the Queechy test came from the environmental.
It came from the environmental board. And it came through like expert testimony, like I said, that the government, knowing that this board could. Part of its role, yes, to resolve disputes, but also bring clarity to these issues, especially in Act 250, where all the criteria, it's like undue water pollution, undue air pollution, and there's a little bit more over time. We've come to rely on with those issues on agency natural resources permits, which have gotten more sophisticated, and so. But it's really the issues like aesthetics and wildlife habitat and natural areas, some of the community impacts, even traffic that's the standard is like no undue traffic. So it becomes, you know, a battle of traffic experts and trying to deal with those issues. So yes, you're right, it takes longer through case precedent, but they have the opportunity if they heard appeals to do it, and then they can turn that into a rule. But they don't have to wait for that. I think that there are things that the LERB can do through rule. And I think once they get through, and as we talk about appeals and where they should go and all of that, I mean, we recognize, and I know everyone recognizes how busy the LERB is right now.
Yeah.
Like, we just created this as the mayor indicated, we're at early days of this, the maps are just coming out. They're doing all the tier 1 maps, they're doing the tier 3 rule, they're doing the road rule guidance, they're doing, rulemaking around a new criteria. But I think once they get through all that, then they will have time and space, right, to do some of this rulemaking and some of that work.
You have another question from here?
So you mentioned that when we see your testimony, do we have?
No, I'm sorry, I didn't say
Okay,
that.
because, a lot of times I wasn't focused on Act 181 when it was being, mulled over in this committee. So I'm trying to catch up
Yeah,
to what Act 181 actually is.
right,
So, and so I'm admitting to my ignorance here, but, my understanding, I didn't even know that, cases actually go now to LERB rather than going to the environmental.
They don't
Oh,
go to
okay.
the, no, they
Oh,
go.
we haven't done it.
We haven't done that.
Okay,
Well, and that's
We haven't
what the report suggested.
Yeah.
Okay.
They did
Yeah.
change.
Okay.
But just so you know, tomorrow we are gonna be hearing from Pete Gill and. No, never mind. Okay, never mind. Sometime in the future, we're gonna have a good like 101 on Act 50, 181, and yes.
But I'll submit this testimony and my prior testimony that just has all this background. And just the last thing I'll say on background is that the way the system was before 2004 is Act 50 appeals went to the environmental board. A&R water permit appeals went to the water resources board. There was a waste facility panel that heard appeals of, landfills and other solid waste management facilities and other issues related to that.
I appreciate your testimony, and I look forward, I'll read it when you
I
send it.
appreciate that.
Yeah.
So then we changed in 2004 and we sent it all to the environmental board, and that kind of created that very large docket. Which, I think is hard, I have sympathy for the judges, I think they do as good a job as human beings can do in trying to manage it. And it waxes and wanes depending on how many appeals that there are, but. Now we're having a conversation, and we've had it for a while, this was part of the Act 250. The next 50 years report, I don't remember how long that was ago, it was more than 5 years ago. They also.
Like 20 years ago.
No, well, that's one of them.
Yeah.
That's the one that Amy was chair of.
I have comments.
But anyway, that's just background. So as we hear all this stuff, I just think it's important to understand kind of the changes that we made. And I know different people disagree about this issue. That's why we've been having testimony for so many years, but this is my point of view. There's other lawyers who agree with me. There are other lawyers who don't agree with me. But the LURB actually did find through its appeals group, a lot of the same reasons that I just stated, that moving appeals to the LURB would make sense. They talked about they could be more flexible. As I said, you're not in court, you can use hearing officers. Right now, I think one of the issues with the court is that like I said, there's two judges, every case is the same. It could be a small zoning dispute about a small project in a community that for whatever reason is controversial, but it's kind of a fight between neighbors for whatever reason. Or it could be a giant Walmart, like that brings community out and everyone's arguing about it. Those cases get the same attention and the same amount of process. There's really not like a prioritization of cases, and this has come up a lot with the housing issue. Like there's, and I do think that the legislature could, and maybe has even. This has become a constitutional issue between the judicial branch and the legislative branch about prioritizing certain matters. I think that the professional board could be directed to prioritize housing, and I think it certainly would have more resources with hearing officers to be able to do that. I mean, and that's kind of, this idea has come up in the last couple of sessions with New Hampshire has a housing board of appeals. That they kind of took all that housing permit appeal, they took it out of the normal process, and so they send it there to sort of experts to prioritize those. So anyway, that's some of the benefits. They recognize the ability to create precedent, so on and so forth. The last thing I'll say about a provision in the LURB appeals report that I want to highlight is that as you hear testimony on this, as you dive into this issue, one of the criticisms that comes up of going to a board model is that it would be a conflict of interest. That the LURB administers Act 250, so how could it hear appeals, and somehow that creates a conflict of interest. The old environmental board administered Act 250, also heard appeals. It wasn't a problem. I'm just going to read what the LURB said because I think they said it well, and they run the program now. And I just want you to have this in mind as you hear from other testimony. So on that issue of conflict of interest, the LURB said, contrary to what some commentators argue, there's no conflict of interest with district commissions making decisions that are then heard by the board on appeal. District commissions are quasi-judicial bodies that make decisions based on facts and law of a given matter. The board has no role in the district commission decision on a given matter. So what they're saying is that they don't, that if an appeal comes from a district commission, the district commission is making that decision. The board does not make that decision. They have no authority to make that decision. Act 181 did not change that at all. But what Act 180 did is provide more resources to the LURB
So attorneys could assist the commissions, you know, if needed and if requested. And so the LURB says, board attorneys can provide legal advice to different commissions on a matter if the commission requests such advice. If legal advice is provided to a different commission, that board attorney can be walled off from working on the appeal of that matter with the board if there is concern about any conflict or the appearance of a conflict. So anyway, I just wanted to flag that, and you're gonna hear a lot about that. And I, you know, please just keep that in mind as you hear the debate about that issue. VRC, so the recommendation, what the LURB did at the end of the day, you heard this, we watched your joint hearing on the House, your House counterparts on this issue. The LURB recommended moving Act 250 appeals to the LURB and housing appeals in Tier 1B areas under Act 181 and all appeals under Tier 1A. We support that as, you know, for all the reasons that I indicated. But I think we kind of ran out of time, and what we didn't get to is some further disagreements about like how those appeals can be processed. And the main issues there, and these are things that you've heard, have to do with de novo versus record review, what the standard of review is for the record review if we have it, how and when to use hearing officers I just mentioned, and that is I think a benefit of a board model. And then I mentioned a board could limit some of the process, provide due process, but as I said, it's a continuum. But so how should discovery be limited? That process of finding out information at the beginning of the case, and even procedural sort of maneuvering that lawyers do in these cases. So I'll just briefly kind of highlight some of these issues, because you're going to hear a lot about them. So de novo and record review. So de novo review is the system we have now. So zoning permits, agency of natural resources permits, and activity permits are heard de novo by the environmental court. And what that means is that the decision that was made that is being appealed is not regarded at all. It has no legal weight or role in the process. So the Act 250 commission decision, different commission, start all over again for whatever the appeal issues are. Same with zoning, the development review board, the zoning board of adjustment, you start all over again. And it was same with the agency of natural resources permit. You don't, you know, the permit is there, it has to be introduced into evidence, but it has no. You're basically taking all the evidence anew. That's what de novo means. Record review is where you either basically say wherever the appeals go, they're just gonna look at the record. And they're gonna look at the record, and the standard of review is there substantial evidence in the record to support the decision that was made? So what the judge is doing in that case, or whoever the decision maker is basically they're not taking new evidence. They basically want to make sure that for all the findings, conclusions, and decisions were made, that there was evidence to support that, and the parties could argue that evidence, you know, there's no evidence to support this finding, and or this evidence was flawed in some way. And then there is some ability, like again, there's a continuum with these systems. You could make it very difficult to submit new evidence in a record review framework, or you could make it fairly easy. So the LURB recommends a de novo review, but giving due consideration to the existing decisions. So they want to actually make the zoning decision and the active decision formally and legally evidenced automatically in the proceeding. That is just in the record and people cite to it and it has legal weight.
But how isn't that contradictory to the whole concept of de novo? Like.
I mean, it's semantics in a way, but then they're saying you could submit new evidence too. There's no limit on new evidence that you can submit in addition to that.
They're saying that the consideration of the appeal would be de novo, but part of the evidence could be the decision that
It
was
will be,
made.
yeah, it's like automatic.
It's automatic.
Yeah. But then you can submit new evidence, and then you could cross-examine people and challenge the evidence that did come in below, but it is in the record, you don't need to resubmit it. And I think there was.
How does it work in court now? I mean, if it's de novo, does that?
Well, so now it's like that.
Get submitted into evidence,
No, sometimes the court will take like what they call like judicial notice of it, like they'll recognize that it exists. But if you cite to it, you need to basically, say, we're citing to this is in the record, and then try to get it admitted into evidence. Like, it's not in evidence, and it can't be part of the decision that the court makes unless you kind of go through that. But it's kind of, they take notice of it for background, like all the parties usually say, because it makes sense, it's like, they usually say, Judge, yeah, read the zoning decision, read that, so then you know you have so many what's happening, right? So you have context, basically, but they can't base their decision on anything, any evidence that is in that decision unless it's resubmitted, as part of the court process, so. So as a practical matter, they do recognize it exists, and I think it is helpful, like I said, for background, but like you can't. You can't, like, the court can't write a decision that says, we're deciding this because the district commission found, blah,
Right.
blah, blah, and then the other lawyer would say, well, wait a minute, that's not into evidence, we didn't get to challenge that in court, so, so you can't base your decision on that. You could use it for a background, unless someone said it would be prejudicial in some way to do that, but most of the lawyers in Vermont don't. Everyone's pretty much, okay, like, let it in for background, but what the slight change the lawyer is making is that it would be in for more than background. It would be like part of the records that could be relied on, and maybe in some cases. That would be enough, like maybe the parties would say, yeah, we stand by what we did there, and we don't need another witness, and. So what the lawyer is trying to do, I think, is split the baby a little bit and trying to say. Like, if we could use the record, let's not reinvent the wheel and let's maybe expedite things, but another approach, which is represented in. Representative Mahaly had the bill that he introduced, goes to full record review, where it's very difficult to produce new evidence. You have to, the standard is something like just cause, and the evidence has to be material to the new decision. And cause is like, why didn't you submit this before, basically? Some of the arguments like for and against, so record review, obviously. On that continuum, the further you get towards using the record, it does speed things up. Because you don't have to put in new witnesses and new evidence, but there has been concern, and I wish Senator Baumgart was here because he has been one of the main voices of this concern, is that it does make the process below more formal. So the district commission process, people will pay a lot more attention into, okay, well, what's getting into evidence there, what is the decision being based on, and same with zoning proceeding, and there is some concern, matters get resolved often at the district commission because it is so informal, and you do know you have to know about review, you can do it all over again. So there's more free discussions about resolving things, and so there's a concern, and you should have Senator Congress testify about it, because he's thought about it a lot, that that would chill some of that informality and have a negative effect. Representative Mahaly's bill has this scheme where you would look at, a case would be designated as like a simple or complex matter. And like that could, determine.
I'm saying bill is simpler, complex. You have to know, but at least we're talking about it.
Yeah, but anyway, this is why this is complicated, because there's lots of ways to do it, and the people don't agree. We are a minority, for zoning permits, I think we're the only state that mandates a de novo review. There are about a handful of states that allow for a de novo review, like you could ask the court for a de novo review, and zoning permits do go to court in most states, but it's not. The vast majority of states conduct a record review. Obviously, most states don't have Act 250, so it's a harder corollary to draw, but just the general principle is most, even like administrative agency appeals are mostly record review. So that's a big issue that didn't get to in the LURP report, and I think it would be worth spending time digging into that, whether we stayed with the court or went to the LURB, and we support moving to the LURB, but I do think that we do need more work in like, okay, where should we be on that record review, de novo review continuum, and what should the rules be if you're going to get to the appeal. Similarly, when to use hearing officers and when to limit discovery, like I said, and when to limit procedural motions. I think as a matter of like a general principle, I think there is agreement that we should have some limits, but like the devil's always in the details, like what should those limits be? How do you determine those limits? And similarly, like A&R permits you can see in the LURB report, they basically said, we're not gonna touch A&R permits. And A&R asked for that. I do think it's fair to like look a little bit more at, we're a real outlier for like agency technical permits and EPA, their permits, their record review, there's an internal administrative appeals review, and when you get to court, it's only a record review of, and it's really legal issues. We're not asking the courts to get into like technical issues related to stormwater or wastewater systems or, you know, whatever it is, because again, that's not our courts, they resolve disputes there. Even if they're judges that are used to seeing environmental matters, it's not their expertise and, you know. So I think it'd be worth having that discussion, and all that's to say, maybe as you're considering what to do this year, maybe it makes sense to kind of delve into some of these. I do think they need more time. And you can look at the Mohali bill, you can look at the Lerb report, you'll see there is like a gap between those, and then you're gonna hear other people come in and say Groveman is wrong about this and that, and you should do it that way, and you'll hear all of that. So I do think, I agree with the mayor that it's important. I do think we can make improvements to the appeal system. And I know it's frustrating that it takes a long time, but these are complicated issues. And I think we made a lot of progress with the Lerb report. I think they did some really good statistics in there. But I don't think we've hit on all those issues that I kind of ran down, and, you know, and you'll hear different opinions about them, and I'm happy to give my opinion at the appropriate time, like as you get closer. But what I really want to do today was kind of frame kind of what the discussion has been and what some of the choices are and what some of the issues are. So that's really my part of this. I'm happy to answer questions, but I want to make sure Katie Gallagher has enough time to talk about the root zone idea that you've had, but also a bill that you have in your committee, so.
Thank you. One question that I just want to connect the dots on something. So a phrase that you used earlier and something that I've heard from the people is like, that you can get as a lawyer in the process of going through, an appeal, that you can get buried by discovery.
Sure, right now.
And so does that, if we were to move to on the record reviews, how does that affect the
Oh, yeah.
burying that can happen?
If it was the sort of Mohali strict record review, there'd be no discovery. Because no new evidence, basically. All of that sort of finding out what the other party's evidence is and arguing about it would happen at the district commission level or at the zoning board level. And I should say, the other issue is really important, I forgot this, is creating that record. So there's a real disagreement about, so some lawyers will come here and say, to create a record, you need a transcript, you have to hire a stenographer. We have a shortage of stenographers in the state, it's absolutely true. Other lawyers will come in and say, you don't need to do that. You could just like, you know, record it on Zoom. You know, you can record them and create a record just by recording it. You don't need a transcript. That could be the record. And all of the evidence that came in, that's the record. So anyway, I think that's another issue that needs to be studied. Is not, and we talked about this in the Lerb stakeholder report, but again, didn't have time. There was just disagreement about what it takes to create a record. But under the strict approach of like, you could just record a hearing and that record goes up and you don't have just cause to supplement the record, then there's no discovery. Because basically the judge, the decision maker, whether it's the Lerb or the court, is like just looking, making sure in the evidence there's support for the conclusion. And then we'll get briefs on the other side and say, there is not, that evidence does not support this conclusion for whatever reason. The evidence is weak, it has a gap in it, whatever it is. And then often it'll be, you got the law wrong. You misinterpreted the law on whatever the issue is. So you wouldn't have discovery. Under the Lerb approach of due consideration or more liberal supplementing the record, you could have discovery on the new evidence that comes in. But it would be more narrow because it would be not the full evidence. And then you could just limit discovery, like the old environmental board didn't allow any discovery. Instead, we have what we call pre-filed testimony, which you can still do with the court, but it's, and then the environmental court doesn't seem, they don't like it. They'd rather just have witnesses come live on the stand, like you'd see like in Law and Order, they like to, you know, and the lawyers like that because it's fun, you know. But pre-filed testimony is you write it all down and you send it to the other side, or you send it to the court. When you go into the hearing, you know everything that the person has said, and then you kind of cross-examine just based on what's been written, and you can do discovery on that too. It'd give you all the documents that every email that you sent, every report that you read, everyone you talked to about this ever in your life, you know? And then, it's objection overly broad and maybe you can win that, but mostly the courts are like, the way courts work, all courts is like, hopefully the lawyers will work this out. They don't want to hear discovery motions, their docket is already overloaded. So mostly it's kind of left to the lawyer to try to work it out. And the process has become like, I'm involved with a couple appeals right now. One is an A&R appeal involving a hydroelectric facility and yeah, I mean, the discovery requests like are incredibly broad. It was, we're scrambling around to get all the documents, there'll be depositions. That takes time, that takes months and months and months, and it takes a lot of money to do all those things. So the environmental board relied on pre-file testimony and the water resources board, no discovery. That was one of the things that moved us to the court. There are a number of lawyers that said, that's not fair, we should have some discovery. The environmental board was actually working on, could we have like, is there a halfway? Could we allow a little bit of discovery? You have to make a case of why you need it and kind of what do you want to ask and can we, and the Public Utility Commission does some of that. So there's a model there. And I personally, that's where I fall out. I was like, I think, under some circumstances, you should be able to ask some of these questions to know what the other person's argument is, but it gets abused, when you just open it up and there aren't any limits at all.
So. In a way, you could boil it down to like, if you don't have discovery, then it goes faster.
Yes, definitely goes fast.
Okay.
It's a matter of like how much profit.
Sure, and how much profit, and then
Yeah.
appreciating your
Yeah.
describing it as a continuum,
Yeah,
like what's the right continuum,
Yeah.
and also appreciating. The reference to the PUC process as a potential model, like halfway point.
yeah.
Um,
The PUC, like, as you've heard, I know you heard testimony this year, over the years, it's very complicated. But I do think that they do have many more tools to limit discovery and limit some of this process and, even within the complexity of like some of their rate cases or like, some of the grid issues, the liability issues that they deal with. And now they're dealing with siting cases, which is where they, I think, have used some of their tools to, because the siting cases really are like zoning and Act 250, right? That's really,
it's very similar.
yeah, anyway.
Okay, thank you, that's
Very
super
helpful.
helpful, yeah, no,
I
that's
Come
great,
back, if you're gonna continue with this, I'll send my testimony and
okay.
you can read it over coffee and enjoy it.
Perfect,
Yeah.
thank you, and welcome.
Thank you.
Yeah.
I know you're limited on time, so I can be really brief. And I also have written testimony that I wasn't able to finalize and share this morning, but I can send it over afterwards. For the record, my name is Katie Gallagher. I direct the Sustainable Communities Program with the Vermont Natural Resources Council. And I'll say I also am on my town planning commission and have a background in planning, so that is the perspective that I am coming from. I also want to say that when we're talking about housing, sometimes I feel the need to share that housing is an environmental issue, it's an environmental solution, and so not just talking about housing for the sake of it, but because I truly feel that we need more housing, we need compact housing, we need more diverse types of housing to meet our environmental and climate goals. So I want to be clear that there's a lot of places where the NRC agrees with Let's Build Homes in terms of of their root zones ideas. We've talked about this together and are continuing to work together. We share the concern that there are examples of frivolous or bad faith zoning appeals that have caused really significant undue costs, delay to housing developments. That is a problem that we would also like to address. They have also referenced the other potential benefits of this proposal in terms of higher quality zoning bylaws, the potential for expanding tier 1 areas, and I think those are all goals that we also share. I think also specifically to tier 1 areas, we talked about, we are going through this really significant process to identify these areas. Are there other ways in which we can leverage those and take a closer look at how zoning appeals function specifically in those areas? All that said, I think as currently framed, we have some questions, and again, I won't get into too many details since we're short on time, but I there's questions that I would offer for you to consider as you're looking at the proposal and the bill. So first, I think it would be helpful to more clearly define what the problem is that we're trying to solve. It seems like this solution might be a little overly complex in some areas, and there's the administration of these types of model codes that are difficult. And then finally, whenever we're talking about limiting appeals, heard from John, and you can go into more detail about it, but you have the risk of limiting residents' due process rights in ways that might have unintended consequences. So just to really quickly go into each of those a little bit more, defining the scope of the problem itself. What I'm referring to here is the question of, are we talking specifically about frivolous appeals? Are we talking about all zoning appeals? Is it a problem because of the delay, like 5-year delay? Or is it just that we don't want appeals at all? So really getting a clearer sense of what it is that we're talking about would be helpful in trying to assess what the solution is. I do want to note that in the Home Act, the legislature made a really significant change for discretionary bodies that we are, part of what we're trying to address here by saying that the Development Review Board or other municipal bodies need to actually follow what's in the zoning bylaws, and so they can't actually say, oh, we're proposing a multifamily home, we're actually gonna require you to do X, Y, and Z because we don't really want that multifamily home, or we want to reduce the number of units. They're not allowed to do that. And that was a really powerful change that, I think is important to take into consideration in this conversation. The idea of model codes, I think, certainly has a place in our broader conversation about how we support our municipalities in either modernizing or adopting zoning. But it's also, important to know, and the previous testimony, you've already acknowledged this, that it's not necessarily like a simple checklist. So just the complexity with which the development of those model codes, I would anticipate it to be like a multi-year process potentially. But also it takes a lot for those to be implemented. It's worth noting, that we have a lack of planning consultants in the state. So even for towns that are trying to just update their zoning or do any of that work, it's really difficult to even hire anyone to do it. And we have a lack of staff, and we're still reliant on largely volunteer bodies. So there's a lot of complexity when we get onto the ground as well with actually making this happen. I also just wanted to raise a question around the proposal for switching from a zoning permit to a certificate of compliance, which is usually what is provided at the end of a development to say, yes, you did these things, or a certificate of occupancy to say, yes, it's safe for somebody to live here. Moving that up front, I'm just not familiar with that being done and how that would work. Well, in statute and in practice, so just something to maybe look at. So then moving on to the due process concerns. Again, just to stay kind of high level, I think there are potential unintended consequences. I think we share a desire to put more of an emphasis on upfront planning and saying, if you are going through a whole planning process, we shouldn't have to have the same fights over and over again throughout each stage, but how that actually plays out on the ground can be complicated. And what we really don't want to do is undermine the whole process and trust in the system. We already struggle with getting people engaged in the planning process. And so we don't want them to turn around and say, we don't want any housing, and that is partly what we are seeing that a little bit, and especially smaller towns that are feeling a certain loss of agency. Finally, I'll just leave you with, there are a lot of existing tools already to address some of these concerns. Municipalities already have tools, for example, they can designate certain uses as by right. We started to do that already at the state level. There can be more targeted amendments to these discretionary standards, like an administrative review or conditional use review, site plan, there's other related processes. We've already started to, I think as was mentioned before, narrow what can be appealed, such as the character of the area standard. Are there other kind of subjective standards like that that we can loop in and say you can't appeal based on this? We have existing programs that are providing really significant technical and funding assistance for towns to update their zoning bylaws, as well as to build that capacity again for them to be able to have more sophisticated zoning. So I just want to note that those are really important programs that are doing a lot of work. We are no longer funding our bylaw modernization program, and so just as we look at this, instead of creating new processes that we would need to fund, I would suggest that we look at some of the existing work that's happening, particularly through the Department of Housing and Community Development, to do this work and build our municipal capacity. I would also urge you to, in your consideration of this, reach out to municipal planners who would have a good sense of how this would play out in the ground. That seems to be a missing body within the recommendation of who would be a part of this potential stakeholder group, and they can provide a lot of insight. So just to close that out, again, appreciate your time. I think this is a good step to, as John said, think about more broadly how we're addressing appeals, but it would be helpful to more clearly define the problem that we're trying to address, whether existing tools can be strengthened to help get at both zoning appeals, building up our local capacity and modernizing our existing bylaws, and carefully weighing the implications of the appeals. Okay, thank you very much.
Thanks so much. Yes,
Is that written testimony?
Yes, I will send it right now.
yes. And I think you've heard this, but of course, Mr. Groveman is going to also submit his testimony as well. Yeah, any other thoughts or questions? Okay, thank you so much. Okay, super. Right, and just to give folks a heads up, we are not going to be hearing from Mr. Burke, who is on our agenda for 11:30. Instead, we are going to just go right into new topic. We've had a whole day of shifting topics. And so this is the last shift for the day. We're gonna move to S 213 and it has an aspect around smart meters. And so for that, invited some our electric utilities to come speak to us about this. So I'm planning on just going right, or do you need to go first or last?
No, I was gonna go together, because I want to
Amazing.
help you,
Okay,
I'm
but I'm going first.
Andrew gets to go first.
And I know we also have Mr. Lazarchuk, who is with us digitally.
Right.
virtually, and so we'll go to him after.
Great.
Great.
Yeah, okay.
Andrea did her homework and has written testimony, so she can go first.
Okay, do you want to share or?
I did send it to you.
Yeah, I have it, but
Oh, I have some copies actually.
Oh,
because I didn't feel like messing with my computer.
Yeah,
today. But we can share this morning. For the record, Andrea Cohen, Vermont Electric Cooperative.
Louis Porter, General Manager of Washington Electric Co-op.
But we can sit with the co-op
Right.
together at the table. Thank you for the opportunity. I did send this to you, Jude, so you have.
It's on the website.
Great, thank you so much. My comments will be pretty brief and Louis can weigh in as well. Regarding smart meters and our history with that, and Vermont Electric Co-op has had smart meters in place since over 10 years now. And our co-op invested very early in that, knowing it was a tool that would really serve us and our members well, and it's a lot of effort and a lot of money, and it really has served us well. Over 99% of our system already has smart meters on it.
And this was the kind of older technology now, it's already cycling around, it was the PLC meters, which is over the power lines, the communication was still on the lines, it wasn't like a wireless thing. And we connect the meters to our substations through the power line carrier. Now we're in the process already of changing our system and upgrading and moving to the RF radio frequency infrastructure. And that's gonna take us several years, because it's a lot of money, and so we're just gonna pace ourselves, so it's not too much at once. That technology works kind of like cellular communication, it's a wireless radio frequency. And we're pretty excited about that, because it's gonna allow us to, the smart meters to be even smarter. People think they're smarter than they are, they're not as smart as people think. The RF will really allow us to have faster, more reliable and more real-time information going two ways. And the system, requires that now. The issue in S 213 that I think you were discussing was opt-outs and how we manage that. So I'll just share a little information. With our system, members have the opportunity to opt out if they do not want an AMI meter, they don't need to have one. We actually prefer that they did, so we don't love that people opt out, we really think it's beneficial to them and us, but if they choose to opt out, they have the right to do so. In our case, they fill out a form. And they submit it, and their responsibility is then they actually have to read their own meter monthly and send in the results, and but we will go out at least once a year, if not more, to check that and make sure that the billing is accurate and everything is right. So opting out again isn't great for the member, because we don't see their outages as quickly, so they actually have to call in and say my power is out. We won't discover that unless they call us and let us know. Also, they can't use the smart hub technology, which they can't see their own usage and monitor usage and all the cool stuff that the smart hub program allows. And then they can't participate in load management programs like EV rates and things like that, because we don't have that kind of information. So there's some downsides to them and us, but it is an option for them. Currently, we have over 40,000, almost 41,000 meters in our system, and currently only 62 people opt out. So if you do the math, that's less than 1/10 of 1%. That doesn't mean as we transition to radio frequency, more people won't, depending on how they feel about that technology. So we are cognizant of it could be more than that. There are cost ramifications. Currently, the time that we have to go and do the manual reads, the time that we have to take to manually input the data, update the billing, it's a hassle and it's time consuming. And again, the problem is, if they're not paying for that cost, if they have the choice, but what ends up happening is other members have to cover, we're spending time doing this and not other things, and therefore there's a little bit of a cost to other members for the choice that those members are making. So when we saw this bill, we saw that there was an opportunity with the water meters for the utility, or in this case to you recoup those costs, a fair cost. We felt like we wanted to offer some language and propose this parallel language for the, so I did offer the language in that second paragraph. And it's just to parallel what you have in S 213. So that was my thoughts on 213.
Great, thanks. We handle opt-outs slightly differently. We have a different metering system, but we have opt-outs also. We handle them slightly differently. But as Andrea said, we are also moving to the next generation of metering technology and expect perhaps more opt-outs. In addition, the way we do the power line carrier opt-outs now is we turn those meters on just for a minute to get a reading and then turn them off again. That's not possible in the next generation of meters. So we will be doing manual reads as Andrea pointed out, or estimated reads, as she pointed out as well. So this is really looking forward. We think your bill on water meters appropriately puts the costs of that additional work to read those opt-outs to those members that do opt out, and support Andrea and Vermont Electric Co-op's language, making parallel changes to the electric system.
So just as a question about the process for that, if we were to allow utilities to charge for that opt-out,
I think I know the answer to this question, but just to say it that the amount of that charge would have to be justified, would be reviewed by the PUC. Couldn't be really out of step with what it's actually costing you to do the reading. Is that accurate?
There are a lot of places where we do actual costs now, and we, in those arenas, we do that justification, explain how we reach those costs and how we allocate them. It's, I wouldn't say there's never a disagreement, but we work those out, and I think it works very well. We're experienced and skilled at allocating costs.
Yes.
We have a process for any of our other fees, because people have us come out and do different things. We have a kind of a menu of all those fees, and what we do is, as you know, we're highly regulated, so we put together a proposal. This is what we think it costs based on, our research, we have to roll a truck, we have to pay the field staff, and we come up with a number, and we go through that process where we can't charge anything that's not approved.
And Vermont may not be unique in preventing those costs from being allocated to the opt-out member, but it's quite unusual. We've been talking to meter vendors as part of this process, and we tell them that, and they're shocked. They're like, well, you can, we say, well, how would you recommend we deal with opt-outs? They say, oh, well, you do manual reads, or you do estimated bills and then true up, and you allocate those costs. We can't allocate those costs. They're like, you can't?
Yeah.
So we made it completely unique, but it's fairly unusual.
Interesting. Yes.
Did you say that the next generation of meters, you're gonna have to go back to reading, that I misunderstand it?
Well, the next generation of meters will not allow you to turn them on and off in the way you do the PLC meter currently. So we won't have to go back to reading them for all the members, just for those that opt in. That makes sense. Not to get too far into the technical details, I'm definitely not a meter tech or an engineer, but basically the RF mesh system requires participation and engagement across the meters. And so you can't just turn one on and off when it's time to read the meter. You have to either have it on or have it off. Obviously, if somebody opts out, we won't not have it on. We'll make it work, but you can't turn them off and on and say it feels.
Maybe another way to say it is just the default is that once it's installed, it's on.
Or off, whichever way.
Oh, okay, right,
Yeah,
fair,
yeah,
yeah.
exactly.
Yeah.
Thank you. Do you have an idea of how many opt-outs you have currently?
Sure, we have 32 opt-outs right now, which is a lower number, obviously, but a higher percentage. We're about a third the size of VEC. We have
Okay.
32 opt-outs right now. But the power line carrier meter does not have any radio frequency. And so I would not be surprised if more of my fellow Washington Electric members opted out under the new system than do on the current system. So we did quite a lot of education and outreach to our members to explain to them that the power line carrier system is a telephone signal across the copper line. I mean, a communication signal across the copper line, just like an old landline telephone. There is no RF, so there may be more people who choose to opt out when there's a radio frequency system. Of course, they should have the right to do that. I also think it's fair that the cost for doing that be allocated to them and not to the rest of the membership at large.
And the one of the things in the bill, and we're still trying to figure it out, but is a requirement that if you do have smart meters, which you do right now, that you have to meet certain cybersecurity and data privacy measures. So could you, I know you're heavily regulated and you have to do these things, but could you just talk a little bit about those so that?
I can, and Andrea probably can as well. Yeah, so our industry and Washington Electric Co-op in particular is moving into the digital world very quickly. When I got there 4.5 years ago, we did very little digitally, and now we do a lot of our work digitally. That comes with an obligation to provide cybersecurity at a very high level because we have members' information and we manage a vital service. So we work with national vendors that manage and develop and manage our systems on cybersecurity. So with one small example, we've moved from having in-house servers for a lot of our data to off-site hardened server farm systems that have redundant servers, so that if we did have a cybersecurity issue, we would be able to quickly scrub and re-upload all that data. So that's one example of the kind of cybersecurity we have undertaken in the last few years. That would be true for this metering technology. I don't know if I answered your question or not, but.
Yeah,
It's both for the member protection, right, so our efforts focus on both our system security, we can't have people messing with our system and taking everything down, right? So there's that end, and then there's the privacy and the personal information, and the vendors we work with, that's like in all the projects, it's first and center and who we work with, and why we work with certain people and other people.
There are.
It's went through a RFP process, right? So-
Yeah. Yeah, we just, VEC, as usual, is a little bit ahead of us, but we just, going through our own, RFP process on the new meter vendors. There's basically two, essential components. There's the management software system, which is called NISC, which works with probably 600-700 co-ops around the country that does the software side of the back end, using the data and helping us manage outages, predict outages, all those stuff. And then there's a metering company and metering information, where any of the vendors that we choose are gonna be national, hundreds of clients around the country, hundreds of utilities and different kinds around the country. And those two will be essential to our, and in charge of our cybersecurity efforts. So although our IT guy is very good, he's one IT guy, one small co-op.
okay.
It'll be them that.
It doesn't necessarily give you comfort that you're using these big national firms, I have to say.
Well.
But I mean, so what are their requirements? Because once you sort of upload your stuff, like who regulates them and how do we know that they're doing what they should be doing?
Yeah, so they are, I hear you entirely. No system is impervious to cyber attack.
Yeah,
However, working with a vendor that bands together millions and millions of dollars from multiple co-ops to create a system and have a system supported, I think makes sense, rather than each co-op spending their own money and develop their own cybersecurity system. They are basically regulated at a national level by the cybersecurity folks, including FBI. And then they're regulated another way, which is they want to win bids like the one we're doing right now. They need to demonstrate a very high level of cybersecurity and a good track record.
does the PUC have any role in regulating your cybersecurity or?
The PUC has a role in regulating everything, like.
Yeah.
Not quite what kind of toilet paper we buy, but everything. So yeah, they will approve, obviously, well, both of us are using state grant money for part of the meter projects. So they have to approve our vendors, and the cybersecurity is part of that. We also have a federal grant that has cybersecurity, DOE cybersecurity standards that has to be approved for selection of our vendor and the implementation of our program. And then, of course, they have to, the PUC regulates all aspects of our revenue, spending, and performance through various, so I'd say there's several layers before implementation and on the back end of oversight.
I think it's fair to say all of our rates, the pressure appropriately so on our rates for doing cyber better, keeping up with that. It's a bigger part of our budget and, will continue to be, right? Because we have to make those investments. So when we talk to you about priorities, that's one that's on, the safety. When we talk about safety, it's includes cyber.
Yeah. Another question?
Something you said earlier, about passing on cost of, can you explain that a little more?
Sure. It costs us, when we roll a truck with a union IBEW meter tech or apprentice lineman in it, that costs us money to go out and read that meter. Then people in the office take that money, take that information back, put it into the bills, put it in our billing system. That has a cost. Somewhere along the line, somebody pays those costs. It's either socialized across the entire membership, or it's allocated, as the chair suggested, at cost to the member who's obligated. So that makes sense.
Just electrical utilities?
No, I'd say the water, well, now I'm I'm always talking out of my depth, but now so I would say the water utilities are similar in terms of how they allocate costs. I don't know the regulatory structure as well as I do on the electricity.
Thank you.
Okay, super,
Thank you.
thank you so much.
I appreciate that.
All right, and we'll move to Mr. Lazarchuk, welcome.
Hello, thank you. I work for the town of Stowe. My name is Michael Lazorchak. Sorry, I can't be there in person. Sorry, I don't have a video that works.
No worries, it's all good.
Yeah, thank you. So the town of Stowe, we have 4,700 meters. We have 18 individuals who have opted out of our AMI meters. We've had AMI since 2012. And we do have 6 AMI meters that are beyond the cellular range for the backhaul. Back to our MDM, we also use NASC for billing. So you have an employee who twice a month drives around and pulls the meter reads from those meters. So it's a little different from how the co-ops do that side of the billing, but we are also a smaller service territory. We also do the billing for the town of Stowe Water and Sewer Department. And they have a fully deployed AMI metering system. I don't know the opt-out rates for them, but they utilize our cellular backhaul. That also goes into NASC. Then we bill out for the town, and then we pass on the receipts to the town of Stowe. We do mandate AMI metering for anyone who is a net metering customer or wants to enroll into a time of use rate or our electric vehicle rate. But again, we have a low opt-out rate like the two cooperatives. I largely agree with what Louis and Andrea have stated. What we do is we charge a fee for the meter installation for AMI, which is the cost of the meter, and then a half an hour of staff time. And that is a flat rate that's provided to the customer before they start service with SCD. Unlike the cooperatives, that provide a list, a list that they update annually. Most municipalities, we just do a straight, this is what it costs. If there's anything else I can add, we find AMI valuable. It helps us communicate with our customers. It helps them see their load. It helps us talk to them about how they could save costs on electricity by changing behaviors. A lot of customers enjoy logging into NASC and checking their pattern, their AMI, and it just allows us a point of communication with them. And then we do utilize the remote disconnect, reconnect, which saves us on costs, which then it will save our customer costs because we don't have to. We also have union linemen. We don't have to get them out of bed before or after hours, roll them overtime, that sort of thing. So I think Andrea and Louis have covered it. AMI is it's a beneficial thing. Of course, if someone doesn't want it for whatever reason, it's fine with us. We'll accommodate our customers the best that we can.
Great, thank you. And so you referenced these AMI meters. Is that what is it? That's an acronym. Do you happen to know what that is an acronym for?
Advanced metering infrastructure.
Oh, okay, that makes so much sense.
Yeah, we use Honeywell. I believe the cooperatives are headed in a different direction, but Honeywell is our first gen. It's just easier to maintain those meters, and then it matches with the cellular backhaul that we've installed throughout Stowe.
Interesting. I'm wondering if so just now I'm having this moment of should we be calling them advanced metering infrastructure? Would that be more technical as opposed to smart meter?
Generic.
That
AMI.
Yeah,
Okay.
I think it's AMI, in my mind is sort of a broader definition. Smart meter would be, in my mind, just the meter. AMI would then be everything that encompasses that meter, like billing, cellular backhaul, et cetera.
That is interesting. Fair enough. And it sounds like you similarly have a very small opt-out rate, but it's still true that the cost for reading those meters is being put onto non-opt-out customers.
Correct, yeah, it's staff time, which then is socialized throughout
Yeah.
the rate base.
Yeah.
And the biggest cost is the meter itself. That's the biggest expense for the utilities. And again, we have union linemen just like VEC and WEC, so those employee costs are gonna be similar. The cost of the meter might differ just depending on the vendor. But we don't mark up the meter. It's what it costs the utility to purchase is what is charged to the customer.
Great. Okay, super. Any other questions? Okay, super. Thank you.
Thank you very much.
Thank you. Appreciate your testimony on this. And hey, well, I guess I'll just say, so we have like, there's a couple minutes. This is something that I'm interested in. And
It's totally question.
what do you think there, Senator Williams? Feeling okay about it? Okay, great.
Do we have a tremendous issue since the volume, since everything is about electric?
I don't know.
Let's say smart meters. Smart meters, it's decided for $1.
Right.
It's good.
Fair enough. Okay, well, we'll see how we can move forward. Okay, I think any other thoughts before we adjourn, any thoughts or comments about anything else that we've heard this morning? Just opening it up.
No, a lot more work to do figuring out the Wakefield Palace and each time we do that.
Yeah, I thought we were getting closer and now I'm not as clear that we're getting closer. So. Open to.
Figure out how to. Down, just
Yeah.
drop the sense of little stuff.
Mhm.
Stuff.
Mhm. Yeah, so we
I
have.
wanted to back away.
Well,
Nothing ever is.
It's there are multiple issues in that same bill, so yeah. Any one of those could be its own thing. So to be continued on that.
Yeah.